Alrighty. Good afternoon. My name is Nicholas Sanchez-Robles, and I'm currently a junior majoring in business management with a concentration. So a few things about me is that I currently work full-time as a realtor back home, as well as a first-gen college student. So I'm a commuting student, kind of straight the line between work and school. But anyways, so you know a little bit more about me. I'd like to present you my final project. My final project is basically over the debate on non-compete agreements, and I'll kind of break down the nature of the issue in the next slide. But anyways, hope you enjoy. So just the nature of the issue and all. Um, First, let me describe what a non-compete agreement is. So a non-compete agreement restricts employees from working for competitors or starting uh, competing businesses for a specific time. So basically, kind of hypothetical situation here. I come work for you, and you have me sign a non-compete agreement saying that if I leave after learning certain things within our company to start my own, uh, it's against the law. But pretty much you can come after me and sue me. We have a contract, bilateral contract that we both agree to saying I can't leave. Um, Non-compete agreements protect trade secrets, intellectual property, and employer investments. And then each state kind of has different rules or laws on non-compete agreements. Like California, for example, just straight up ban non-compete agreements, while others have reasonable restrictions. I'm not too exactly sure what Kentucky has on non-compete agreements. Like I said, California straight up bans them. As you can see here, different states have different opinions on them. Next slides here. So the FTC proposed this rule back in April 2024. Basically, they proposed a rule to ban all non-compete agreements nationally. Um, and pretty much through the ban, they require rescission of all existing non-compete agreements within 180 days after the ban goes into place, which was in September 2024. Uh, Exceptions, of course, for businesses of sales of potential ownership stakes. The FTC argues that pretty much non-compete agreements harm competition. So they can't, like I said earlier, I just can't leave you. So it kind of harms competition amongst them. And they argue pretty much promotes monopolistic type businesses, economies, suppresses wages, and potentially increasing annual wages by $250 billion if the ban goes into place, allowing people like me to leave your company and go start my own. So arguments in favor of non-compete agreements, pretty much you protect the trade secrets and sensitive business information. You encourage investment in employee training, promote innovation by safeguarding intellectual property, and facilitate stability in mergers and acquisitions. So this right here was one of my first pieces of the articles that I researched. Pretty much found that a U.S. federal judge in Texas named Ada Brown ruled that the FTC exceeded its authority, calling the rule arbitrary and capricious for failing to target specific abuses. The impact behind this, the decision blocks the ban but allows challenges to abusive clauses. Um, and the significance is pretty much highlights tensions between regulatory power and judicial interpretation. Getting a little tongue tied here. Arguments against non-compete agreements, like I said, pretty much reiterate it. They just say, hey, it suppresses the wages and limit worker mobility. Disproportionately impacts low-wage workers. So, believe it or not, some even lower-wage workers are more susceptible to non-compete agreements. Um, High-growth industries like tech thrive without non-compete agreements, such as California, i.e., Silicon Valley. Um, the FTC's authority to impose the ban is legally contested. So this right here goes back to that Texas ruling, and also a different circuit court in not circuit court, excuse me, different judge in Florida ruled. They both ultimately ruled uh, opposed the ban, but kind of for different reasons, and I kind of want to highlight those here. So, like I said earlier, Judge Ada Brown ruled that the FCC lacks statutory authority to issue the ban, declaring the rule arbitrary and capricious for taking a broad, one-size-fits-all approach. She also criticized the FTC for failing to explore targeted alternatives. And then in Florida, Judge Timothy do not want to butcher his name, but Judge Timothy acknowledged the FTC's authority to regulate unfair competition, based the ruling on major questions doctrine. Sorry, I'm a little gas here. Requiring clear congressional authorization for significant actions. The court pretty much ruled against the ban because the FTC could not, uh, provide that congressional authorization. However, the FTC has appealed both of these decisions since this, and this could lead down the road, depending on how the circuit kind of splits up, circuit court split up, could lead to a Supreme Court review. The Supreme Court of the United States is likely to assess this with a regulatory scope under involving standards, the post Chevron doctrine changes. So since the FTC is appealing, it is not all sunshine and rainbows. They do have a definitely difficult path. They have to pretty much address every argument raised by the challengers, not just the ones in the central to the lower court rulings. Federal appellate courts, pretty much, they're just saying, hey, courts like the Fifth and 11th courts apply the right for any reason doctrine. This allows the appellate courts to affirm lower court resorts for any valid legal reason, even if not relied on originally. And then also just the practical reason behind it, the plaintiffs attack the non-compete ban on multiple grounds, making it challenging for the FTC to succeed on their appeal. So my perspective on this whole entire thing is, I do hear both sides of the arguments. I don't think it's appropriate to straight out flat ban it, but I do think there needs to be some reform, especially for the lower wage workers, and allow tailored agreements for executive and sensitive roles, and for stricter standards and reasonableness, like scope and duration. And there just needs to be more transparency on what these agreements are. And I feel like there should be laws that the employer has to let the employees know in contract negotiations. There just has to be more transparency because, if there's not enough transparency, then the employer is kind of going in on he knows more than the employee doesn't, and that kind of puts him in a vulnerable state. But like I said, the conclusion is, I do think national NCAs serve legitimate business purposes but require careful regulation. The Federal Trade Commission proposal highlights the need for fairness and balance. And like I said, a middle ground approach is probably the best way to solve this. Don't need a ban. I think we just need more reform. We just need to try to increase the awareness and just make it more transparent for the employees to better understand it and the employees to better get it out to them. Like I said, here's my sources here. I also have the links we can click on to low. I will say the first source there, Westlaw. I did it to the WK libraries. I don't know if you can access it. You should be able to access it through the WK libraries. But like I said, thank you again. This course has been a pleasure. I will say, out of most of the online courses I've taken, this course right here has been one of the most well formatted, easy to understand, just all around. It's a great structure course. But thank you again. It's been a pleasure. Hope you have a great holidays. I know I'm getting close to the 9-minute mark. It's supposed to be 7, but if you could kind of subtract out my intro and subtract out my conclusion, just wanted to say thank you again and have a blessed rest of your evening.